Hi, this is Anthony Parent of Iris Medic, and in this video, we're going to be answering some of the most common questions people have about renouncing or expatriating in U.S. citizenship. Now, this is a tax channel, so we're going to hit some of the tax topic later on, but we thought it would be a great idea to answer the most basic questions people have about renouncing their citizenship. Now, joining me is our friend Keith Redmond, a global advocate for the American overseas. He runs American Expatriates 2.0 on Facebook. And along with our friend John Richardson, John is an attorney based out of Toronto, and he helps a lot of U.S. persons with tax and citizenship solutions. He runs citizenshipsolutions.ca. Gentlemen, thank you so much for joining us today. Now, right on. I am going to sue. So let's see here. Who wants to answer this one first? This is actually the most common question people have. They're going to, John, why don't you answer this one? John, can you renounce your U.S. citizenship?
Oh, absolutely. The laws, Section 349 of the Immigration and Nationality Act, defines the rules for expatriation. In other words, divesting yourself of U.S. citizenship nationality. Renouncing U.S. citizenship is one of the ways of doing it.
Okay, well, there it is. I guess we asked the right guy. Our next question is coming the other way. Do you have to renounce your foreign citizenship if you wish to become a U.S. citizen?
The answer, are you wanting me to answer that?
Yeah, John, if you could.
Yeah, the answer is, I think absolutely no is the answer. But that said, the ceremony to become a U.S. citizen does include a statement that you are renouncing foreign citizenships. But the law of renunciation, divesting oneself of citizenship nationality, is a country-specific type of law. So let's say somebody's a citizen of, say, Canada, for example, who becomes a U.S. citizen, and during that ceremony says, yes, by God, I renounce all other citizenships. That would have no bearing whatsoever on their Canadian citizenship, because the rules for divesting oneself of Canadian citizenship would be under Canadian law.
Okay. Well, I mean, there's a really good question. There's a really good reason why people ask this question, because a lot of these oaths sort of have this thing where you're sort of implying a renunciation, but you're saying not quite. Now, here's a question, Keith. Maybe you can help with this one. You've helped a lot of people make this tough decision, and we've known a lot of people who've made this tough decision. How long does it take to renounce your citizenship?
Well, I think it depends on the process. I mean, there are some people who will become U.S. tax compliant because they're not in the system and do so, which would take a little bit longer than those who choose not to be U.S. tax compliant and just go straight to get their CLN, their Certificate of Loss of Nationality. That's point one.
Okay, well,
go ahead.
Well, what's the quickest time? If you had everything, all your ducks in a row, and you just said, okay, you know what, today's the day, I want to start my renunciation, and let's assume you're in 100% tax compliance.
The quickest time, I would say I have seen it done in a couple months, but it depends on where you go to do the process, because in some countries, at some U.S. embassies and consulates, they have a backlog. And so it can take as long as a year to 18 months. Depending on where one is located. But I've seen it as quick as a couple months.
Yeah, and I've actually seen it in a few weeks. Poland. Yeah, Poland. Yeah. Ryan Sokash. He actually scheduled it, and he gave me the date. He said, yep, here's the date. And it was a couple weeks out. And he says, yep, it's done. And so really something. So it depends on where you are, but it can go really quick. But what Keith's point is, that's assuming you are to the point where you have all your ducks in a row, and sometimes there's some compliance work that needs to get done, and we'll be talking about that a little bit later. Now, who wants to?
Can I just add something to this? Okay, although there may very well be tax consequences to renouncing U.S. citizenship, the reality is that there's no legal connection between tax compliance and renouncing U.S. citizenship, and as they expect, we'll be talking about the new relief procedures for foreign citizens. But, the initial bulletin that came down on that, and I believe it was September the 5th, 19, I made it very, very clear that they're fully aware that there are plenty of people who renounce U.S. citizenship without tax compliance, and that was the reason for the relief procedures in the first place. So, I mean, I'm not saying that taxation is irrelevant, but there is no connection between those two things, and that's why, for many people, if they want to fly somewhere quickly, they can, as you point out, renounce U.S. citizenship within about a 3-week period.
Well, here's a question for you, John, if I may interrupt for a second, because I get this quite a bit. Is it against the law, against U.S. law, to renounce your U.S. citizenship without being U.S. tax compliant?
Let me give you a very clear and simple answer, okay? It is not against U.S. law. It is not against any law, and there are plenty of people who do it as a matter of simple fact. But that doesn't mean that it's a good idea. Let me put it to you this way again. There is no law, absolutely no law whatsoever, that requires U.S. tax compliance to renounce U.S. citizenship. I think I'll say it again. There's absolutely no law whatsoever that requires U.S. tax compliance to renounce. However, renunciation may trigger certain tax consequences, specifically the exit tax. So all of these things must be considered as part of one's thinking.
Thank you so much, John.
Thank
this
you.
is John, this is the tax channel, and I threw my bias at this question because you're absolutely right. They are completely different things. The way I'm answering the question is the way our clients typically ask the question, when can I be done with this? That's really what, because they're coming, when can I be done with the IRS is sort of their question. And that's sort of the perspective that I was answering it. But you're absolutely right. They are two separate things, and one will trigger the other. But you're right. You can renounce without any tax compliance and then deal with the consequences then. So maybe that's why you might want to talk to someone like John.
Well, I'm not recommending that, okay, and I'm not, whatever. I mean, I'm just simply answering Keith's very specific question. They are not, as a matter of law, related. I will tell you, as I'm sure you would do the same, that from a practical point of view, the first thing I get somebody to do who wants to renounce is we have a look at their net worth. You would begin with a Form 8854 and work backwards from that point, I think, unless it's clear. Well, even then, we've got to get into the tax compliance issues.
All right, so Keith, you want to answer this one? How much does it cost? Now, we're not going to talk about any tax consequences, but just how much does it cost to renounce? And because renouncing doesn't really have anything to do with your tax, so just what's that fee? It's $100, right?
Yeah, it would be nice if it was $100. Actually, the current amount is $2,350. And that's been that amount for the past few years now. Prior to that, it was $450. And prior to that, it was $0. So since the implementation of FATCA, the U.S. State Department has augmented the cost of renunciation, hence the exorbitant cost of $2,350.
How much? So that's oh my gosh. All right. That is some bad news. Now, here's some questions we have. John, you want to answer this one? Can you renounce your U.S. citizenship and still remain in the U.S.?
Well, you can't renounce okay, so what does it mean to renounce U.S. citizenship? Well, it means that you cease to be a U.S. citizen. So the question really is can somebody who's not a U.S. citizen remain in the United States? And the answer is no, not unless they have a legal status, which would include, which means status under the immigration laws. Now, what I find interesting about this is that if you look at this from the point of view of a Canadian, where not only is a visa not required to enter the United States, but basically nothing is required, for a Canadian to renounce U.S. citizenship, it's not that big of a deal from an immigration perspective because they can just, go to the United States. But for somebody who's a citizen of, say, Iran, if they renounce their U.S. citizenship, then they're going to have to, I think, work an awful lot harder to get some kind of legal status to be in the United States. And to that I would add, by the way, that there's nothing that prohibits somebody who renounces U.S. citizenship to go through the normal immigration channels, again, including getting a green card, if that's what they want. Although I have a lot of trouble imagining why somebody would do that after renouncing U.S. citizenship, but okay.
Yeah, and if I may add to that, just to that question, to add on another aspect to it, is that if you are someone a U.S. citizen living overseas, and you do renounce your U.S. citizenship, you can travel to the United States, whether it be for business or for personal reasons. You're just treated as a non-U.S. citizen. So if you're part of one of the visa waiver countries, you can stay there up to 90 days with no problem. And I know many people who have done so.
I think the way that listeners should understand this is you renounce U.S. citizenship, you're treated exactly as a citizen of whatever country you are.
Yeah.
I think what people want to know is there a punishment? I think that's so. Okay, so I think that answers a lot. So I think we have a whole host of questions that are sort of the same thing. Can you get your how about this? Can you get your citizenship back if you renounce? I don't know if anyone's ever done that or would try to do that. But I would assume why not?
Good question. Of course you can, but not because you were a former U.S. citizen, but if you go through the normal immigration
process. Exactly. Right. What happened? You married a U.S. person, and that was your sponsor for citizenship. Right. Same thing. And so the same thing. Can you get a visa after renouncing? Yes. Can you get a green card? Yes. So these are the things. It's the same treatment. So that's good to know. Now let's get into this issue where we talked before. How does one renounce their citizenship? And now we know it's not some form you file with the IRS to renounce your citizenship, but it's something else. John, why don't you tell us how one renounces a citizenship?
Okay, with your permission, I'd like to broaden your question slightly, okay, to govern, thank you, relinquishment in general. Okay, how does one relinquish citizenship? Recognizing that renunciation is just one way of relinquishing U.S. citizenship. So I think the better way to view this is, how does one relinquish? And that would include renunciation. Well, again, if you go to the statutes, Section 349A of the Immigration Nationality Act, what you'll see is that, actually, I'm going to slow down here, okay? If it's a renunciation, okay, you absolutely positively have to go to the U.S. consulate, stand there, take an oath of renunciation, etc., etc. But remember that renunciation is one form of relinquishment. And for nationality purposes, it's entirely possible to have relinquished U.S. citizenship or to relinquish U.S. citizenship without getting a certificate of loss of nationality, that is, without going to the consulate. Now, you got to be careful, okay, because for tax purposes, the relinquishment is effective only from the date of notice, right? In other words, when you do go to the consulate. But if you are wanting to just relinquish, for example, somebody who, and by the way, relinquishment requires the intention to relinquish, but let's say somebody becomes a citizen of, say, Canada, let's say in the year 2012, and that person became a Canadian citizen because he or she specifically wanted to no longer be a U.S. citizen and intended to relinquish. That person, okay, would have ceased to have been a U.S. citizen for nationality purposes from the point of having become a Canadian citizen, right? No visit to the consulate is necessary, and no certificate of loss of nationality is necessary for nationality purposes. But all U.S. citizens are dual citizens in the sense that there's both tax citizenship and nationality citizenship. And for tax citizenship, since 2004, in order to relinquish or renounce, there's a requirement that you get the CLN, that you go to the consulate.
All right. Now, when is there so the difference between your relinquishment to renunciation? To repeat that again, relinquishment is a type of renunciation, or the other way around?
Renunciation is a type of relinquishment. Okay, renunciation is the only type of citizenship relinquishment that specifically must be done at a U.S. consulate or embassy.
Okay.
Other types of citizenship relinquishment, let's, for example, look at becoming a citizen of another country. If you become a citizen of another country, if you naturalize a citizen of, say, Canada, with the intention at that time okay, of relinquishing your U.S. citizen, then from that point on, you would have ceased to have been a U.S. citizen for nationality purposes, meaning that you would no longer have a right to enter the United States as a U.S. citizen, okay? But the Internal Revenue Code in 2004 created a second kind of U.S. citizenship, right? In other words, U.S. citizenship is the greatest, the bestest, so why not give everybody a second type of citizenship? And that's tax citizenship. In order to end U.S. tax citizenship, a certificate of loss of nationality is required, at least since 2004.
Got it.
Okay?
Fantastic.
Prior to 2004, and this is where it gets interesting, okay, it's debatable, all right, whether a CLN is required to have lost U.S. tax citizenship. My personal view is that it is not required. There are some people who disagree on that. It depends whether you read Section 877A of the Internal Revenue Code, enacted in 2008, retroactively or not. I don't think there's any basis for reading it retroactively.
Got it. Thank you so much. Beautiful explanation, John. Really appreciate that. So you brought up, though, now I think this is a great time to talk about the tax consequences. And so why don't we say this? Oh, and there was one question I wanted to get in here. Oh, I can't remember it right now. It comes up all the time. Hopefully I'll get to that. We want to talk about the tax consequences of what if you're not in compliance. Let's say that. And because this is really a big reason why people are driving to give up their U.S. citizenship. They're living overseas, and the burdens of the citizenship-based taxation are just too much. Whatever they're making, it might be okay, but when they add up their compliance costs and the fact that they end up owing nothing to the IRS, they really can't see the point of it. So there's a huge amount of people who are considering giving up their U.S. citizenship who might not be in tax compliance. So why don't we answer the question for them? What if they just say, hey, you know what? I'm just going to give up my citizenship, and I'm going to say I'm done. I guess if the IRS wants to come after me wherever I am, they're more than welcome to. What would you say to someone like that?
Is that directed to me?
That's directed to you, John.
Oh, I would say whatever, but I think you should understand what the tax consequences are of not being in tax compliance, and specifically not certifying the 5 years of compliance prior to the renunciation. Your listeners can go to Section 877A of the Internal Revenue Code that lays this type of stuff out. Now, if you do not or cannot certify 5 years of tax compliance prior to your renunciation, you become what's called a covered expatriate. Now, the consequences of being a covered expatriate are basically twofold, at least in terms of what the statute says. The first consequence is that you're subject to the U.S. exit tax regime. And although it's more complex than this, I'm going to say that means two things. The first is that there's a deemed sale of all of your capital property, even though you haven't sold it, and you would pay a capital gains tax on that. But there is a $700,000 floor. In other words, you would be exempt on about the first $700,000 of capital gains. That's usually not the problem. The problem is the tax treatment of, what practically speaking are foreign pensions. If people renounce and if they're a covered expatriate, and this is very, very nasty. What it means is that the full present value of the pension would be included in the income for a one-off tax. So let me give you a very down-to-earth practical example here. And this is something that I see a lot. In Ontario, I live in Ontario, Canada, specifically Toronto, and I work with a lot of teachers who have built up over their years very, very valuable Ontario teachers' pensions, which can exceed $1 million, or university professors, which are even higher, generally $1.5 million. Now, the problem here is that if this issue came to a head, and somebody could not certify the 5 years of tax compliance and therefore would be a covered expatriate, okay, the full value of that pension, say $1.5 million, actually gets included in the 1040 in the year of expatriation. So let's say $1.5 million. What's the top rate of tax on that? 37.5%. That would be the amount of the tax owing. Notice that because there's been no realization event in Ontario, it's never been paid out, there's no foreign tax to offset that. So, I think that there are huge incentives for this reason for people who renounce U.S. citizenship to come into tax compliance. Now I'm fully aware of, all the stuff there is in the online world, the chatter and stuff like that. But I think that for a lot of people, honestly, nobody likes the U.S. tax compliance thing. But for a lot of people, it's really not that big of a deal. Okay, at least in comparison to the possible consequences down the road. Now, I'm not saying, to be clear, I'm not saying that I have any sense at all that, the IRS is out there trying to hunt people down who are non-compliant and have renounced. I don't have a sense of that at all. But the reason people want out of the U.S. citizenship thing is primarily because of reasons of anxiety. They don't want to worry about it. They don't want to think about it. Now I am not a tax preparer, to be clear, okay, just, before I say this. But my personal view on this is that the people who can clean this up easily, okay, without owing a bunch of U.S. tax, I think it probably is in their interest to do so. That's my view of it. There will always be people who file because that's in their DNA. There will always be people who don't file, because that's in their DNA. But I think people, at a minimum, need to understand the consequence, at least the theoretical consequences of being a covered expatriate. Okay, now there's a second theoretical consequence, which I am seeing, I'm having more and more discussion about this with people, is the problem that if they're a covered expatriate, if they, when they die, leave a bequest or make a gift to any U.S. person, that U.S. person is going to be subject to the gift tax rules on that, which could be as high as 40%. So I'm going to give you a practical example here. Let's say you got somebody in Canada who has now listen carefully to this, okay, because it shows you how this problem becomes bigger over time. Let's say you've got somebody who's got a small business that's worth, say, even $1 million, okay? Let's say, and let's say that they're not compliant with the taxes, so they become a covered expatriate. Let's say they have that business for 30 more years, and it becomes worth $100 million at the end of the 30 years when they die, and they pass that business on to a U.S. citizen child. It's the $100 million that gets hit with a 40% tax, not the value at the time of renunciation. So, look, there's probably nobody who's, I'm going to use the word hostile to this regime than I am. All right, I doubt it. Okay. Soulmates. All right, but I think that people have really got to be careful here and understand what these rules actually are and what they could mean. Now, whether these will practically mean anything to somebody, I don't know. Okay, I don't know. And I'm not saying that I have any, inside information, but it just seems to me that, if it's easy for people to tie this up from a tax perspective, I mean, why wouldn't you? Okay, this is not about ideological considerations. It's about practical life decisions. Anyway, that's my view of it.
John, thank you so much for that. And you brought me to some points there I think the thing is when people are watching us and talking about us, we are going to be talking about the most superlative examples of the biggest outrages to say, hey, look out for this. We don't want our clients to be surprised by something horrible. So we're going to tell you a story like, hey, look, watch out for this. Here's a treatment where somebody really got it bad. The truth of the matter is, most of the cases, most of the people we work through it. Oh, it actually wasn't that bad. And when you get into the exit tax, you're worried about that. There's things you can do. We're having clients, we're doing some planning. We're bringing that exit tax way down. Everything can be dealt with. But here's the thing. Sometimes a little bit of advice can go a very long way. So, and I think as a minimum, you should at least know what you're saying no to. You should at least, if you're not going to say, you know what, I'm not going to be in compliance, you should at least know, hey, look, we just want to show you what the cost is and how much it's going to take. Then you don't have to worry about anything. So at least do that if you're on the fence. I think a lot of people are right, though. They'll just do it like, hey, look, I just want to do the right thing. That's most people. I don't want it to hurt too much. That's most people. But you brought me up to now, and I remember the question I wanted to ask again, because you brought it up in a previous podcast. There are certain people, when they have an exit tax, when they expatriate, they could be far over that exemption amount. They could have millions, billions of dollars and not owe 1 cent.
The dual citizenship exemption of the exit tax?
That's right.
Yeah, okay. Yeah, that's a good thing to talk about, okay? But I want to make something very, very clear here. Very clear, all right? Before I describe how the dual citizenship exemption works, I want to make it very clear that it's available only to people who are compliant for the 5 years, okay? All right, it's not just a generalized exemption. You have to have been tax compliant. Now, let me take an example here. You've got a U.S. citizen living in the U.K. that was born a dual citizen. And you have to be a tax resident still of the UK, right? All right. So it's not, this is a general overview. For God's sake, get a competent advice if you're contemplating this, okay? But the general principle is this, that if the dual citizen from birth can satisfy the 5-year compliance test, then their net worth will not matter. Normally, if it's over $2 million, which is awfully easy to do if you own a house in Toronto or London, okay, you're going to be a covered expatriate. But that person could have $1 billion of net worth and not be subject to the exit tax. All right, which, by the way, is why, I think it makes good sense for a lot of dual citizens from birth living in the United States who are very high net worth to move from the United States and establish tax residency, in their country of other citizenship, right? To be able to satisfy that test. But yes, such a thing exists. It needs to be understood. It's not as simple as it sounds, but it does require tax compliance, or you're still stuck with the exit tax principles.
Yeah, and
I'd like to.
Oh, go ahead.
I'd like to throw out a.
Go, Keith.
Yeah, I would like to throw out a question to the two of you on this one and get your input. Based on just what John was saying and your questions, Anthony, what do you say to someone who is living in a country, let's say France, that has specifically stated that the French tax authorities will not do the bidding for the IRS? Knowing that that will not occur, should they proceed differently with their renunciation? Meaning, do they have a little bit more leeway in maybe not being U.S. tax compliant and just getting their certificate of loss of nationality, knowing they have the protection of the country and where they have that second citizenship?
Here's my answer first. I'll take this one first, and then John, you can follow up. I would say, well, that's basically every country. Every country has the same thing. If you're living in another country and you have a legal right to be there, and you haven't done anything criminal, rather this is just some civil non-compliance you are dealing with, the IRS isn't going to get a lot of help from other countries. Now, there are some countries in which there are mutual enforcement agreements, but those require you to have, and I remember, I think Denmark's one of them, you have to make a substantial amount of money before anyone could really attach it. And still, it's not like they're really going to out there looking to help the IRS. And so the IRS has this sort of big threat But for most of the time, it's empty. The only problem is sometimes it's not. And it's those times for sometimes when that threat isn't empty that we have to watch up to. But if somebody, if they want to make their own call, that's up to them. They have no need for me. Do what you want to do. Hey, but don't look for me to say, hey, everything's going to be okay, because I simply don't know that. John, what's your answer? What do you think?
I see this discussed all the time on the blogs. And
I get these questions all the time too. Yeah, so that's why I wanted to ask it.
Let me just sort of feel my way through this a little bit, okay? First of all, let me just say this, that I think, Keith, you're thinking primarily of the accidentals who are not in the U.S. tax system, right?
That is correct.
Yeah,
that
okay.
Is correct.
So now, my personal feeling on this is that, but this is me, nothing but my personal feeling, and therefore is just musings, million light years away from advice. But I think it's unlikely that, the IRS or anybody's going to go after that group of people. I mean, how do they even know about them? Sort of thing. Well, the answer is, of course, that the State Department forwards to the Treasury Secretary information about anybody they issue a CLN to. So they do in that sense, but of course, the IRS wouldn't know a great deal about them. So unless they want to, make an example, I don't know for sure, okay, but that's not the type that I think needs to worry as much, okay? Now, let me try to answer this as well as I can. There's a difference in life between a U.S. tax debt and the ability of the IRS, the American government, to get a foreign government to assist with enforcement of that tax debt, okay? There's a difference. If you look at the countries that have these new treaties, which really are breakdowns of the revenue rule, okay, they do, by the way, have mutual assistance. All right, in other words, the IRS can get information, all right, from Canada or from France, this sort of thing. They just can't use the revenue authorities of France and Canada to help actually enforce the U.S. tax debt. But the problem is, if you see it as a problem, is that it is a U.S. tax debt. So I think what needs to be understood here is the fact that people who are French citizens or Canadian citizens may have protection from collection under a tax treaty is irrelevant to the existence of the tax debt itself. Now different people have different views on that. For some people, that's fine. They don't care. For others, they would be bothered by the existence of a U.S. tax debt, period, and would, take steps to avoid that. For the life of me, I really have a lot of trouble understanding why the people who can't deal with this whole set of things by the book relatively easily, it just seems to me that it's in their interest to do that. And, and I am absolutely on their sides and, in every respect on this, but this has to do with their lives and just getting out of this garbage. And it's it's a bad thing. I mean, there are bad things that happen to good people. I think there's a book on that, right? And unfortunately in the 21st century, a bad thing is being a U.S. citizen abroad, and you can accept, I think a lot of people just accept that it's bad and deal with it. Rather than accept that it's bad and have that bad thing, to carry around the rest of their lives.
Yeah, and I mean, we had our clients, to deal with stuff. They made a decision in 2013, 14 to deal with this. And this is ancient history to them. You bite the bullet, and put it in the rearview mirror very fast. And here's one thing, and here's because there's a lot of little tricks. You might be thinking like, that's all right. I'll just wait out that. I'll wait out that tax debt. But there'll be a tax debt, they can't collect it, and I'll just wait it out. Okay, maybe you will, maybe you won't. Just, again, make sure you never have any assets or income coming in from the United States, because if you're overseas, that's tax debt never expires. If you're in the U.S., it expires after 10 years of assessment. Overseas, it goes on indefinitely, so...
There are people who presumably have never been in the system, so there's never been any assessment anyway. So there's nothing to expire. Look, this is not a one-size-fits-all sort of thing. Yep. And I think that what's important for an advisor here is to help people understand, a combination of the practical and theoretical consequences of various courses of action. A lot of people, I think, would be well served, okay, by just renouncing, using the new relief procedures that I think are far more favorable to the old Streamline.
Why don't we go through those right now? What's the new process? What's the highlights of it? What's the benefit?
Well, so the highlight of it, these are the relief procedures for foreign citizens that took effect in September of 2019. And by the way, they continue to evolve, so they're not quite what they were in September. But it seems to me that the highlight of it is you don't need a social security number one. Okay, which is good because it doesn't provide any particular link, to the IRS. Secondly, it applies only if your net worth is below 2 million US, which, you can figure that out on your own. It's a total of 6 years, the 5 years prior and the year of renunciation, but they're all filed at once after the renunciation has taken place and there's a certificate of loss of nationality. I think that it is, it's an improvement. It's an easier way, I think, for the people who, made the decision that they don't want to invest any more of their life in this problem, to get on with it. And also, if you look at the FAQs, there is some suggestion that the compliance requirements are somewhat relaxed, particularly in the area of non-U.S. mutual funds. There's no FBAR requirement, although they suggest that you file them. And interestingly, there is no requirement of an independent certification of non-willfulness, the way there is with the Streamlined. And, the combination of those things, I think that there's nothing about it that's good in the sense of any requirement to file is bad. And I'm sorry, I forgot, there's a forgiveness of $25,000 US of tax as well.
Hey.
On that. So, for the people who owed odds and ends of, who they are, Anthony, these types, right? That's helpful as well. So I am inclined to think that in a world where there is a compliance requirement, okay, in a world like that, I think it's a great improvement over the Streamlined. I think it's it's a step forward. Okay.
And John, I think there's something you forgot to mention, and correct me if I'm wrong, that
probably
one of the other requirements is that they've never been in the U.S. tax system.
Yes. Thank you for that, Keith. Absolutely. There's a requirement that they've never been in the U.S. tax system in the sense of having filed a 1040, meaning they haven't filed as a U.S. citizen before. In other words, and also the relinquishment of U.S. citizenship has to take place after March 18th, 2010, what's the significance of that date? That was the date that FAQs was enacted.
Oh, right. Okay.
Yeah. So, I think it's an improvement, okay? It's definitely an improvement. It's sort of like, it's not quite as toxic and putrid as the rest of the system.
Well, yeah, and I would say this, if you don't qualify for this, you probably still qualify for the Streamlined. If you live overseas, the Streamlined can be pretty good. Oh, if you live in the U.S., it might be okay. But don't...
I would make, before I forget it, Anthony, I'm sorry, would be this. We talked about the dual citizenship exemption, okay? Now, notice that for the new relief procedures, you have to be below the 2 million. Okay, if you're above 2 million in net worth, you can't use this. Mm-hmm. So if you wanted to use the dual citizenship exemption of the exit tax, you're not using this, right? Okay, then you're going to use Streamlined or something else. I have heard from 2 or 3 sources who I consider generally reliable that Streamlined is that the days of Streamlined are numbered.
Really?
Yeah, that. I don't know what that means, but I'm just saying the people who've told this to me are people who are generally credible, reliable, and thoughtful.
Well, I mean, I heard OVDP was ending we heard it was ending about a year before it did.
Yeah.
The
yeah,
full
there's
ODP
no-
we heard. We were like, yep. They were like, yep. All the revenue, all the disclosure examiners were telling us that there was ending. So we knew that about heads up. So I'll start looking around to see if that's what we're hearing too. But I mean, a lot of ours don't get examined.
Ask the question directly. My guess is that there's not going to be a long lead time, on the announcement of that. But listen, I don't want somebody to interpret that as, oh my God, I've got to do something quickly. You never do anything until you've decided what it is you want to do. That's for sure. Okay, don't do anything under panic, etc. But even if Streamlined ends, okay, obviously, there will be a mechanism, to come into tax compliance. But you're moving from streamlined definitions of non-willfulness, which I think are easier to satisfy, to presumably more traditional notions of reasonable cause and this sort of stuff that are, I think probably doable, but
that's actually the first that we heard. That was actually the first. You telling me that was the first that I heard. So, and I think I want to end it here. We're about out of time, and I think we're gonna reiterate the thing that we say again and again. There is no one size fits all. There is no one size fits all. If you're sitting, you're looking at this like, oh my God, this is a nightmare. There's no way I'm going to get out of it. I can't afford it. Stop that. You actually don't know. You actually don't know. I would say talk to someone like John or someone like my firm, citizenshipsolutions.ca. Visit him if you like him, or give us a call at irsmedic.com. Also, be sure to visit Keith's Facebook page, American Expatriates 2.0. Even if you're in the U.S., you'll see a lot of this. Oh, wait, I don't know if we want that. Wait, we don't want that, Keith. Those U.S. people sometimes don't get it so much, right? Right, bud?
It's always good to educate.
Yeah, well, that's what we're trying to do. And it's a common thing that we're doing, and it's just one of the things that we have is we have a bias of homeland Americans who think that people who have things overseas have it easy, not understanding that the compliance is absolutely insane, and that a lot of stuff really never gets taxed by the IRS, and we're just creating work for everybody. I don't want to hammer around too much. We've been over that a million times, as you might know, if you subscribe to this channel, which I advise you do, because we'll be talking about some more things along the way. And with that, this is Anthony Parrott. I want to thank again our guests, John Richardson and Keith Redmond. Thanks for watching.